Hello, this is Kim Clark.
Hi, Ms. Clark. This is Marc Stevens. I'm going to connect in a moment.
Okay, great.
All right, just hold on.
Hello.
Yes, just see if we should be able to get you guys connected here now.
Okay.
All right. Okay, Ms. Clark?
Yes.
Okay.
Yes, I'm on the line.
All right, we're all on.
Good.
Great. Okay, and Mr. You're recording this call, is that correct?
That's correct.
Okay, so I'm just going to do a few preliminary things first. This is Kim Clark. It's December 15th, and this is a telephone conference call with docket number 1726-08L. Mr. Could you identify yourself?
This is.
And we also have on the line Marc Stevens.
That's correct.
And Mr. Stevens, are you Mr. Jackson's representative, or are you just on the line?
I'm his representative today.
Oh, okay, so are you a CPA, or do you have a power of attorney?
I have a power of attorney, yes.
Okay, for Mr.
Yes.
Do we have a copy of that power of attorney on file?
No, I have not sent that to you.
Would you be able to fax that to me?
I can. You mean right now?
If possible, yes.
Well, I can't. No, I don't have a hand right at the moment.
Okay. Well, I just want to get verbal confirmation from you, Mr. Today we're going to be discussing your personal income tax information, and I want to make sure we have authority to disclose that information to Mr. Stevens.
Yes, you do.
Okay, great. Oh, I think that is the preliminary information. I just wanted to make sure, given our disclosure regulations, that we could discuss your income information. The purpose of this meeting is to prepare this case for trial. As you know, we're supposed to agree on all the facts that are not in dispute and submit something called a stipulation of facts to the court, which includes documents and any facts. It would include copies of your administrative file if you're willing to stipulate to that. Do you have any documents that you're planning to introduce at trial, Mr.
Well, just because of the time, Ms. Clark, we wanted to discuss first as far as what you're planning to bring and what you've gotten in the informal discovery request was not responded to. So if we could start with what facts and evidence and witnesses you rely on, that would get us through this quicker. We could save a lot of time.
Okay, so first of all, we have the administrative file, and our position is that at least for 1999 through 2001, the court should be reviewing our determination under an abuse of discretion standard. So we want to admit the administrative record to show that there wasn't an abuse of discretion. And of course, that would be necessary if Mr. Jackson was arguing that there was an abuse of discretion. Because if the court doesn't have anything to review, they can't determine whether there was or was not an abuse of discretion. And we sent a copy of the administrative file to Mr. Jackson last January or February, I believe. The next thing, if you're planning to dispute any of the income that I discussed in the Brannerton letter, I'd like to know that just really fast.
Well, I think what's in dispute is the issue of the taxable income. So which witnesses do you rely on to prove that Mr. Jackson is a taxpayer under federal tax law?
Witnesses?
Yes.
We're not planning to have any witnesses unless Mr. is not going to stipulate to the administrative file at this point. I mean, that may change by the time we do our trial memorandum, but at this point, we don't have any witnesses to call.
So you don't rely on any witnesses to prove that Mr. is a taxpayer under federal law? This is just your opinion?
Mr. Stevens, this is not an opinion. We're discussing whether we're going to, how we're preparing the case for trial. I'm not planning to call any witnesses during the trial.
Okay, so all right. I'm just trying to verify this, and so that we understand. So if paperwork is filed in court, there's less of a chance that you're going to think we're taking your statements out of context. So you're saying that at this point, and let's just discuss this freely as if we're not actually going to trial. Do you have any witnesses to rely on to prove that, with personal first-hand knowledge, that Mr. is a taxpayer under federal tax law?
I can see where you're going with this, Mr. Stevens. As far as relying on witnesses with first-hand knowledge that he's a taxpayer, that determination was made in the administrative file, and we're relying on third-party information, which was reported to us by several payors that gave reported income to Mr. Steven during the taxable year of 2002 at least.
So let me ask you, is there someone in this administrative file that will be identified as a witness with personal knowledge that Mr. is a taxpayer?
The administrative file lists all of the people who made determinations along the way as far as the notice of federal tax lien and the notice of intent to levy.
Okay, would they qualify as witnesses with personal knowledge that Mr. is a taxpayer under federal law? I mean, would you feel comfortable calling any of those people as witnesses that they're qualified to testify against Mr. and that he's a taxpayer under federal law?
Now, if we're going about the definition of a taxpayer,
no, I didn't ask you that.
Discussing?
No, I didn't ask you that. I'm talking about a witness with personal knowledge that's qualified to testify in court that Mr. is a taxpayer under federal tax law. I didn't ask you about a definition. I'm just asking you about the if you have a competent witness to testify against him.
Well, if we're having competent witnesses testify against him, then we're preparing for trial. And I am not planning to call witnesses at trial at this point.
Well, at this particular point, what we're trying to establish is that you don't have any witnesses, so that when you call in your paperwork, when you refer to Mr. as a taxpayer, you're doing that based on your own knowledge or it's your own opinion. It's not actually based on a competent witness that you can rely on at trial.
Yes, and this is something that you can make arguments to the court about. But at this point, we need to discuss preparing for trial.
Well, that's what we're actually doing. So do you have any witnesses with personal knowledge that Mr. Jackson has taxable income under federal tax law?
I'm not planning to call any witnesses.
Oh, okay. So just to clarify, you see, there's a fine distinction here. I don't want to be accused of, or have Mr. Jackson be accused of taking you out of context when you say that you're not planning on bringing any witnesses, and then we bring into court that you don't have any witnesses, and you say, well, no, I didn't say that. So I need you to clarify. Do you have any witnesses that you rely on, at least during the pretrial stages, to prove that, with personal first-hand knowledge, to prove that Mr. Jackson has taxable income under federal law?
At this point, I'm going to say that this is going to be a frivolous argument, and I'm not going to discuss that during this pretrial conference.
What frivolous argument are you talking about? I'm asking you a question. What are you leading to?
I think at this point, I'm going to need to end this call.
Why? I don't understand. I'm asking you for witness. I'm asking you basically what witnesses you rely on. You think that's frivolous?
I'm not relying on any witnesses at trial.
Okay. Are you relying?
We have information from third parties that has stated that Mr. received income from them.
Okay.
These years, and I'm trying to determine whether he received that income, and then we can argue whether it's taxable in front of the judge.
Well, I don't think we need to do that. We're trying to maybe possibly avoid trial. If you don't have any witnesses with personal knowledge that he has taxable income, because the third parties didn't determine that, that was had to have been shown at the Internal Revenue Service. If you don't have any competent witnesses to rely on, and Mr. has taxable income, then you could just say that. That's not frivolous. The last time I looked, asking for witnesses that were competent to testify has never been determined to be a frivolous argument. And if you believe to the contrary, you need to cite a Supreme Court case that actually lays that out, because that would be a huge shift in American law. We just want to know specifically, do you rely at this point in the pretrial on any witnesses with personal knowledge of Mr. had taxable income? Hello?
Sorry, I was just trying to think of a response that would, at this point, let's see. I know what you're trying to get at.
Well, I'm just trying to get at if you have witnesses with personal first-hand knowledge that he has taxable income. That's what I'm trying to get at. I'm not making an argument. Mr. isn't making an argument. If it comes out that you don't have witnesses with personal knowledge, we'll make an observation to the court, not an argument. We will let the court know that you don't have any witnesses with personal knowledge to support your accusations against Mr. That's not an argument. That's an observation based on what I've said to you. So
Yeah, I see where you're coming from.
yeah, I'm just asking for witnesses. That's all I'm doing. I'm asking if you have witnesses with personal knowledge. There's no ulterior motive here, Ms. Clark.
Well, as far as I know, there aren't any at this point. I'm just going to say at this point.
There aren't any.
Not that I'm planning to call during trial, and not any that would... Okay, so what I'm trying to say is that at this point, I'm not planning to call any witnesses that would have first-hand knowledge that he is, in fact, a taxpayer under the code.
And taxable income.
Well, as far as taxable income goes, we've made that determination.
Well, I understand that.
So I don't know who filed the substitute for return at this point, and so I can't say that. But whoever did the substitute for return determined that he had taxable income.
Okay, do you want some time to get with the Internal Revenue Service to find out who that individual is?
Well, I can find out. I'm actually looking into that right now.
Okay.
I've made inquiries.
Now, if a subpoena was to be issued, would you fight or move to quash a subpoena for the agent who did the assessment to appear at trial?
Yes.
On what grounds?
At this point, that it would be unnecessary.
So it's not necessary to have the actual person who did the assessment testify under oath to its veracity?
Well, let's just say I would object.
On what grounds?
At this point, I don't have grounds at this point, but we're going to object if you try to subpoena the person who did the substitute for return.
Oh, but you don't have any grounds any legal grounds to make. Why would you want to oppose that? I would imagine that if you are relying on this unknown individual who made this assessment that you think is valid, I would think that you would be subpoenaing, bringing them into court yourself to bring into court, put him under oath, and prove once and for all that Mr. is a taxpayer with taxable income. Why would you oppose that? Why would you oppose actually making a case? I mean, what you're saying is like a prosecutor who has a traffic ticket, and if I'm the defendant and he's accusing me of speeding, and I subpoena the officer to come in and testify to verify his complaint and his accusation, that you as a prosecutor would fight that. I would hope to think that the judge would have the integrity to then throw your ticket or your assessments out. But again, I'd like to know why you would fight against having your own witness on the stand.
Well, at this point, well, now that you said it that way, I don't know whether we would or not.
Oh, okay.
I'd have to determine, I'd have to see the subpoena first, and then we would make a determination on whether we would move to quash it.
Yeah, it's kind of odd that, you would...
Well, I'm saying it's very possible that the person is no longer with the service, or the person is on the other side of the country. So, I mean, at this point, we would have to see.
Oh, okay, I understand. So now, do you have any witnesses that have personal first-hand knowledge that Mr. was required to file a tax return on the federal law?
Okay, I'm not going to discuss that question. That question was in Mr. Johnson's repeated request for discovery.
Yeah.
And he filed it with the court, and the court said I don't have to answer those questions at this time. I'd like to discuss what I sent Mr. Johnson in the mail, the Brannerton letter, requesting documents from him. Does he have any documents to support any expenses or anything for 2002?
Well, as far as I know, the judge had mentioned that we can ask for permission, get leave of the court to submit the discovery again, and we're here today to possibly avoid trial or to narrow down the issues for trial. So if you don't have a witness with personal first-hand knowledge who's required to file a tax return, that would be some facts in dispute. So I think it is relevant and something that we need to answer today. I mean, it's no different than the answers you gave me on the previous two questions. If you don't have any witnesses, okay, just say it. If you don't know who it may be, and they may be on the other side of the country,